by Dr. Yoho, and my great friend from Florida who gets common sense right in this Congress, that I'm a fan of the Canine Corps, and I'm also a fan of the B9 Corps. And I want the B9 Corps to be thinking about what that means. It's not just a bingo game, but it is bingo for a cancer patient. And so when you get the diagnosis of K9 or B9, I'm taking B9 over K9 because that's the thing that we celebrate more than anything else, is that lease on life, that if it goes 5 years, you're cancer-free. B9 cancer-free for 5 years, that gets the job done. Thanks for standing up for the Canine Corps. And I'm now going to stand up for the unborn Corps. Thank you, Dr. Yoho. And I did, Mr. Speaker, I came here to the floor to speak this evening about this nation, and about a nation that has granted to its Supreme Court, sometimes just because we weren't paying attention or we didn't have the confidence of our convictions. I suppose there was a time when Americans were no better informed on constitutional principles than we are today. And over the years, 216 or so years, we've had this experience of accepting the idea of Marbury versus Madison. Marbury versus Madison, a Supreme Court decision that over time, with it accumulated decision by decision, rooted back in Marbury, that the Supreme Court of the United States was the final word in what the Constitution says. The Constitution doesn't say to the Supreme Court that you have the final word, but instead it's court precedents, case precedents that laid the foundation in about 1802 that's been built upon ever since. And the longer we accept the tradition of a Supreme Court decision being the final decision on what the Constitution says, the more deeply ingrained is the commitment to that decision, and the less our Constitution itself means, and the more the traditions of the acceptance of a decision of the Supreme Court means. And so here we are today. If people aren't quite understanding, Mr. Speaker, what that means, I would describe it a bit of another way. There's a practice in this country called birthright citizenship. There's nothing in the Constitution that requires that a baby born in the United States is an automatic citizen. In fact, the 14th Amendment to the Constitution, ratified in 1868, says that all persons born in the United States and subject to the jurisdiction thereof are American citizens. Well, post-Civil War, they knew what they were doing, and they didn't think we would confuse it over the years the way we have, but they wanted to make sure that the babies born to the newly freed slaves as a result of the Emancipation Proclamation and the Civil War would be American citizens. And they expected that those babies born to the former slaves would be full-fledged citizens, that have all the rights of citizenship bestowed upon them as those created in the image of God, just like everyone else. But what happened was, even though the amendment was there that said all persons born in the United States and subject to the jurisdiction thereof are American citizens, over time, in the latter part of the 19th century, they began to bestow citizenship on any baby born in the United States. And it wasn't successfully challenged, neither is any case on point, in all of the full history of the litigation that's taken place that's found its way to the Supreme Court. There's no on-point precedent case that determines that the Constitution requires that a baby born in America be automatically an American citizen, but the practice has prevailed. The practice has prevailed along the way that a baby born on U.S. territory, with certain exceptions, is an American citizen, even though the Constitution doesn't require it, because the subject to the jurisdiction thereof clause that's in there meant a number of things. First, that meant loyalty. Where is your allegiance? And there were Native American tribes, called Indian tribes at the time and still today, Indian tribes that if the children born on that reservation were American citizens automatically, they were automatically removed from membership in the tribe. So the folks that drafted the 14th Amendment wanted to exempt them, and that's one of the reasons they inserted the clause subject to the jurisdiction thereof, because the allegiance of those born on reservations wasn't viewed to be equivalent to that of those who were born in the other territorial areas of the United States of America. And then, of course, they wanted to exempt the children born to ambassadors, the children born to diplomats, the children born to their staff. Could you imagine that if there was an invading army and babies were born to the folks that followed along on that army, that they would be American citizens? No. They weren't subject to the jurisdiction thereof. They didn't owe their allegiance to the United States. It was clear they owed their allegiance to other foreign princes and potentates, to borrow a phrase from the naturalization oath. And so the clause, subject to the jurisdiction thereof, exempted those who were not obligated to owe allegiance to the United States. But the practice persisted. It persisted to this day. In fact, some years ago, sometime about a decade ago, we had hearings, and in those hearings, the research, at least the testimony, said that somewhere between 340,000 and 750,000 babies that were born in the United States where both parents, the mother and the father, were illegal. And yet, they've been bestowed an automatic citizenship, and it's created this birth tourism where back during that testimony time, now the price has surely gone up. If there is a pregnant mother in China, she could buy a $30,000 ticket to fly into the United States, be smuggled into the United States, get her OB care, and live in an apartment next to the hospital, deliver the baby, and have that little baby's feet stamped on the birth certificate, and that little birth certificate made that baby an American citizen. Then they loaded the baby up and flew the mom and baby back to China. And 18 years later, that baby could begin to petition to bring in the family reunification plan. That's how a practice gets started that hasn't been successfully blocked because of litigation that would go to the Supreme Court with a decision made based upon justice. And so this situation persists. 750,000 babies a year or more. I mean, the entire population of the dreamers every single year born in America to illegal parents, granted automatic citizenship and the ability, once they reach of age, to begin the family reunification process and bring in the whole kit and caboodle of family into America and start them on a path to citizenship. What kind of nation would do that? A nation that's steeped in a precedent of habit, a bad habit, that persists in delivering a policy that's not constitutional, but rooted in a murky understanding of what the Constitution actually says. I wouldn't say a dishonest, but a misunderstanding of what the Constitution actually says. And so, that, Mr. Speaker, I think sets the foundation for the decisions on Roe versus Wade and Doe versus Bolton and Planned Parenthood versus Casey, and a number of Supreme Court precedents that built us up to this situation that we have today. And I am speaking of abortion in America, abortion on demand in America, babies that have a chance to live outside the womb being killed because they're inconvenient, they're maybe at the time not wanted by the mother. We're seeing data that shows that a significant percentage of mothers who have abortions are coerced into that by the biological father who doesn't want to carry that responsibility. And what is this based upon? Supreme Court precedents that are looking back on it. How did they ever build to the position that we're in today? Back in the 60s, there was a case known as Griswold versus Connecticut. And that case was one where a family in Connecticut, a husband and a wife, I don't know if they're parents, a husband and a wife in Connecticut wanted to be able to buy contraceptives. And because of the Catholic influence in Connecticut, they had outlawed contraceptives in Connecticut. And so they went to the Supreme Court, the Griswolds, and said we have a right, we have a constitutional right to purchase contraceptives, and it's not the business of the state legislature to tell us that we can't purchase contraceptives. We want to take care of our own reproductive rights by managing our contraception. And so the Supreme Court stuck their nose in what should have been a states' rights issue and came down with a decision that manufactured out of emanations and penumbras, not even whole cloth, but the imagination that there was some cloth there to manufacture it out of, the right to privacy, that the Supreme Court concluded the right to privacy would guarantee the privacy for the Griswolds to be able to purchase contraceptives, even though the state of Connecticut said it's against the interests of the people in the state of Connecticut that we control birth through contraceptives. That was their decision in Connecticut. If people wanted to vote with their feet, they could have left Connecticut. But instead, the United States Supreme Court decided they had the power and the authority to manufacture a whole new right that doesn't exist in the Constitution, a right to privacy. And a right to privacy guaranteed the ability for the married couple to purchase contraceptives. Well, that was sometime in about mid-60s, and not very long after that, the Eisenstadt case came up, and it was this. An unmarried couple said, why are we excluded? We have the same constitutional rights as the married couple has. If they have a right to purchase contraceptives because they have a right to privacy, unmarried people have also a right to privacy. And so the Supreme Court decided, okay, we had started down the slippery slope, and we had granted this right to privacy and a right to purchase contraceptives and keep the government out of the private lives, especially the reproductive lives of people, consenting adults. How can we deny the unmarried couple the constitutional, manufactured constitutional right that we have always granted to the Griswolds? So the Griswold case became the Eisenstadt case, and the non-married couples had the same rights as the married couples. Along came 1973. Two cases came before the Supreme Court. Roe versus Wade, Doe versus Bolton. Roe versus Wade took that concept of a right to privacy that was manufactured, not out of the Constitution, manufactured out of thin air, out of the emanations and penumbras, which means in the shadows of, where the text of the Constitution is. And they decided that a woman had a right to abortion, and it was an inherent right rooted in a right to privacy. You have a right to a contraceptive. You have a right to put an end to the life of that innocent unborn baby under the same standards of privacy. Now, who gets to take the life of a baby or child or a young adult or a mature adult or a senior adult? Who gets to do that by saying, it's only my business, I control that, it is my right to privacy? But the Supreme Court concluded exactly that. But they did say that that could only happen in the first trimester, and then, but that simultaneous case that came down was Doe versus Bolton. And in the Doe versus Bolton case, they gave exceptions, Mr. Speaker, and said that, well, okay, we're going to restrain this right to an abortion that we've created and manufactured in Roe versus Wade, but we really can't say that if the woman has danger to her life, that she shouldn't be able to get an abortion. Sure, we'll give her the right to abort her baby if it risks her life. How about if it risks her health? What if it damages her health? What if it affects her psychological health? What if her familiar relationships are going to be upset if she doesn't abort the baby? In other words, what if a young lady doesn't have a husband and it would be disturbing to her family for her to have the baby? We want to give her the right to abort the baby because it would upset her familial health, her family life. And of course, if it affects her economically, it affects her psychologically, and it might affect her familial life as well. So if it affects her economics, her psyche, her physical health, risks her life, then abort the baby. She has her right for all that. So when you take it together, Roe versus Wade and Doe versus Bolton, it was abortion on demand. Manufactured by the Supreme Court of the United States, Mr. Speaker. Not written into the Constitution, but pulled out of the emanations and penumbras, the shadows of, that little shadow around the cloud out there that maybe we can't see it because we are just lay people with normal perceptive abilities. We might have the best eyesight. We could have 20/20 vision. Well, we can even have 20/20 rear vision to see what's going on. But the court put on their black robes and they looked up at the sky and they decided, we know what's written in that place around the edges of the clouds and the emanations and penumbras. We know that it's there because we want it to be there. And we can't read it exactly into the language in the Constitution, but we want it, we see it, and we're going to shape society around it. And they did. And they came down with the Roe versus Wade decision and the Doe versus Bolton decision same day, January 22nd, 1973, abortion on demand. And how many of us at that time knew what that would mean, Mr. Speaker? How many of us understood the devastating debacle that was served up to the American people? I remember those times. I remember those years. Marilyn and I were married in 1972. And as we looked around at our friends, our contemporaries that were young couples that were getting started and started with their families at the time, we knew a decision came down, but we had no idea how bad it would be. And no one in 1973 would have predicted that 45 years later, we would have experienced 60 million abortions in the United States of America. 60 million babies whose precious lives, perfect little babies created in God's image. No one would have expected that there'd be 60 million on the conscience of America. No one would have expected that we would hear the business community clamoring for labor, saying, we don't have enough people to go to work in America. We have to go to foreign countries and bring in millions of people to do this work. Nobody out here is even doing the math to say what happens when 60 million babies are gone, ripped out of the generations over the last 45 years. What does that do to the society? What's it do to our economy? What's it do to our morality, the conscience, the guilt of America, the sins on the soul of the United States of America? What's it do to all that? But what does it do also to the next generation, the next generation? What about the guilt that's carried by the people who stepped in and took the advice of Planned Parenthood and decided, really isn't a life and there aren't any repercussions. I can be free of the burden of raising a child that I had not planned to raise and walk away and life will be fine again. What's happened to the people who bought into that story? What's happened to let's just say the family force, the workforce of America? 60 million babies ripped out of America, ripped out of the womb, ripped apart out of the womb, ripped out of America. 60 million babies, 45 years. And Mr. Speaker, if you do a back of the envelope calculation and you think of those little girls that were aborted, many of them would be mothers again today. They'd be mothers by now. And I did a back of the envelope calculation, and I will say that I just figured that if each little girl that had been aborted since 1973, in those years that they would be of reproductive age, and some of them wouldn't be of that age yet, but if each of those who would be had had 3 babies, as Marilyn and I have had, that's another 60 million babies. 60 million. So now the hole in our society is 60 million babies plus another 60 million babies. 120 million Americans. And you could dial it down a little bit. You could say, well, they aren't going to average 3. That's probably true. Could average maybe 2.5 or a little better. But if you take the 120 million and you dial that down a ways, I can tell you, Mr. Speaker, what the population of America was 100 years ago. Let's pick the 1920 census. 106 million Americans was the total population of the United States of America in the census of 1920, which comes up in a couple of years. It'll be a century in a couple of years. 106 million Americans. That's how many we're missing today. All of that many babies, all of that million developed adults, young people that would have lived, loved, learned, laughed, played, raised families of their own, gone to school and gotten educated, started businesses, created jobs, improved the quality of life of all of us, enriched our lives. The love that would flow from over 100 million babies growing up in America that were denied the right to life, the right to live, and they were taken from this world before they ever had a chance to fill their own lungs with air and scream for their own mercy. That's the burden that America is carrying today. And when that day comes, Mr. Speaker, when that day comes that abortion is over in America and we respect and we revere life again as it once was and one day ever shall be, when we reach that point, that doesn't mean that America is absolved from this sin on our nation. What it really means is we can begin to put our pieces back together and build a history and a legacy of a love and a respect and a reverence for life, all life, life from the moment of fertilization until natural death. And by the way, that life from moment of fertilization till natural death is the mission statement of the National Right to Life. The National Right to Life's mission statement, I'm not reading it, I'm going from memory, so if I miss a word, but it says they're dedicated to protecting life from the beginning of life until natural death. And I embrace that mission statement. I embrace that ideology and that philosophy that shaped that mission statement for the National Right to Life, the country's oldest and largest pro-life organization. But I did ask the question, how do they define the beginning of life? And I looked down through their website, and it's defined from fertilization. Life begins at fertilization. That's the mission of National Right to Life. And we agree. And I applaud that position. And I applaud the work that they've done over the last more than 45 years because they formed themselves before Roe versus Wade, I believe 1968. So they should be applauded for the work that they've done over the years. But National Right to Life is married to a concept of incrementalism. And when you read through the statements, the testimony that they've supported before various state legislatures, the positions that they have taken, Mr. Speaker, it becomes, and as I have done, sat down and talked with their leadership and tried to convince their leadership to be stronger, more bold. The same answer came back from each one of them that I talked to at National Right to Life, and it's this. They are committed to doing what can be done around the edges. The Supreme Court has built a fence around the right, what they call a right to abortion. There is no right to abortion. There's no constitutional right to abortion. It is manufactured, as I said earlier. But National Right to Life, the nation's oldest and largest pro-life organization, has built a fence around the Supreme Court decisions. And they're working incrementalism to try to get as close to that fence around the Supreme Court decisions as they can without being reversed by a decision of the court. And that is their strategic approach. And they have been granted a de facto veto power to any legislation that would come to the floor of the House of Representatives that doesn't have their support. I said de facto, and that's the net result of it. In fact, that is the result of it. And so we have 170 co-sponsors on the Heartbeat Protection Act, the piece of legislation that says before a doctor can perform an abortion, commit an abortion, he must first check for a heartbeat. And if a heartbeat can be detected, the baby is protected. We know if there's a beating heart, there's life. And if there's a beating heart and you go in and stop the beating of that heart, you've ended that life. The most innocent lives that there are those unborn little babies. And if there's a heartbeat that can be detected, the baby must be protected. That's the bill. That's the Heartbeat Protection Act. But national right to life doesn't support, they say it this way, Mr. Speaker. National right to life, they say, they say national right to life does not oppose the heartbeat bill. Does not oppose, which is, it's a little bit of semantics, Mr. Speaker. So I struck through the does not oppose, and I'll put it there in exactly the same meaning. They do not support. If you're the national right to life and you're committed to protecting life from the moment of fertilization till natural death, how do you not step up to support the heartbeat bill that protects babies from the moment a heartbeat can be detected, the baby is protected? And their rationale is, our strategy is not here on heartbeat. Their strategy is try not to ever challenge the Supreme Court of the United States. And so how can we have the nation's oldest and largest pro-life organization that has entrenched in a philosophy and a legislative strategy that says that they're never going to challenge the Supreme Court of the United States? If you're not going to challenge the Supreme Court of the United States, then it's on your head and on your conscience of anybody, not just national right to life, but anybody who says, I'm not willing to challenge the Supreme Court of the United States, I'm not willing to challenge Roe versus Wade, Doe versus Bolton, or Planned Parenthood versus Casey, then you are de facto accepting the idea that there will be, accepting the actual reality of 1 million abortions a year as far as the eye can see. That's what this language here that says the national right to life does not oppose the heartbeat bill. I say they do not support the heartbeat bill. Both statements are true. But opposing, challenging the Supreme Court decisions of Roe versus Wade and Doe versus Bolton guarantees 1 million abortions a year as far as the eye can see, over the horizon of history and out of sight, 1 million a year. We've seen 60 million abortions in the United States of America in the last 45 years. That this ratio that we're on today, if the population doesn't grow, and if the ratio stays the same, and it sure looks to unless we do something, we're looking at 1 million a year, and 45 years from now, another 45 million abortions. And another 15 years later, we're back another 60 million. And then it's 120 million babies, and we know how that works. Then those babies not born to the mothers who would have been giving birth to them, you can double the number again. But already, we're missing the entire population of the United States of America of 100 years ago as a result of the abortion since 1973. And this nation must step up to the moral principle that every human life is sacred. They're sacred in all of their forms. In fact, Governor Bob Casey, Democrat governor of Pennsylvania, since passed away, God rest his soul, said human life cannot be measured. It is the measure itself against which all other things are weighed. Well, I am prepared to, and at least 170 House members are prepared to, go to the Supreme Court again if challenged, pass the heartbeat bill out of the House, pass it out of the Senate, send it to the President's desk. The President will sign it. The other side, the pro-abortion people, will litigate it, and it'll end up in the Supreme Court. And the Supreme Court needs to decide, are they going to reflect and honor life? The 14th Amendment requires that we protect life over liberty. And in fact, there are prioritized rights of life, liberty, and property in the 14th Amendment. And in the Declaration, it's life, liberty, pursuit of happiness, but always life is number one, Mr. Speaker. Life is always number one. And this country must step up and defend human life. And I want to, from the floor of this Congress tonight, put a shout out and congratulations to the Iowa Senate, who moved a very similar heartbeat bill by a vote of 30-20, passed it off the floor of the Iowa Senate with a 24-minute debate. It was all the longer it took, 24 minutes, and a 30-20 bipartisan vote came off the floor and got messaged over to the Iowa House of Representatives. And they're in serious deliberations today. I don't know the results of those discussions. I left there last night with optimism that the heartbeat bill in Iowa would come to the floor there soon, perhaps as early as next week. And should it pass, then it's likely to go to the governor's desk. And I do not have her public statement, but I will just say that I have confidence that Governor Reynolds will sign a heartbeat bill if it gets to her desk. She is a solid, principled, clear-thinking leader who is also pro-life, Mr. Speaker. And so we're doing the things that we can do to protect the lives that we can protect. But it is not good enough to play a perpetual strategy of incrementalism. Incrementalism of a little bit here, a little bit there, try this, try that. What has it done for us? It's saved a few lives. It really has. And every life is precious and worth saving. But it's not good enough. It's not good enough to accept the idea that we're going to see 1 million babies aborted in America every year as far as the eye can see. So that's why the House of Representatives and needs to get the heartbeat bill to the floor where I believe the votes are there for it to pass. National Right to Life needs to lead, follow, or get out of the way. Right now, the #1 entity in the entire United States of America that's holding the heartbeat bill off the floor of the House of Representatives is right here, the nation's #1 pro-life organization, the National Right to Life. Reconsider. Justice Kennedy has announced that it is announced at least, and not by Justice Kennedy yet, that he's likely to retire midsummer. We will have a pro-life court by September, and it's time to move now. And that's my message, Mr. Speaker, and I ask all of us to stand up and protect innocent, unborn human life, and let's start to cleanse again the soul of America. And with that, Mr. Speaker, I yield back the balance of my time.
Gentleman yields. Does the gentleman from Iowa have a motion?
Mr. Speaker, I move the House do now adjourn.
The question is on the motion to adjourn. Those in favor say aye. Those opposed, no. The ayes have it. The motion is adopted. Accordingly, the House stands adjourned until 10 a.m. tomorrow for morning hour debate.